Although it is unethical, unjustifiable, and a shocking intrusion on people's bodily integrity and human rights, the states have the technical legal power to mandate vaccines. The only solution is to tell them you oppose it, and if they don't listen, vote the wannabe tyrants out of power. Let's talk about some claims regarding mandatory vaccination. I completely oppose mandatory injections, but there are some false claims about their legality. Some people may not like the information I'm about to share with you, but I can assure you it's accurate. I wish it wasn't, but there is nothing to gain in misleading you and giving you false hope. Firstly, can the Commonwealth Government make COVID vaccinations mandatory? The Australian Constitution in section 51, paragraph 23A, does not provide an authority for mandatory medical treatment on a person. That would include vaccination. It does allow the Commonwealth, though, to fund treatment, but not to compel it. Because the power to mandate treatment was not given to the Commonwealth under the section 51, clause 23A of the Constitution, the Commonwealth cannot mandate treatment under this provision. There are provisions in the Biosecurity Act 2015 made under the Commonwealth's quarantine power that in limited circumstances may authorise directions for individuals, but not for groups of people. The states, on the other hand, can mandate treatment if they pass legislation to that effect. Section 51, paragraph 23A of the Commonwealth Constitution does not restrict the states at the moment. Victoria and Western Australia already have explicit legislation in place that could force a person to be vaccinated. There is nothing to prevent the other states and territories from passing similar enabling legislation to be in line with Victoria and Western Australia. The result of that is that if the Prime Minister can persuade the states and territories to follow his line, they can enable the Commonwealth demands. Is this morally right? Absolutely not. It would be a backdoor way for the Commonwealth to sneak around the Constitution on enforcing injections. Scott Morrison can't do it because of the Constitution. So he's getting the state governments to do his dirty work. Another issue that requires some explanation is the effect of section 109 of the Australian Constitution. This says that if there is a conflict between a valid Commonwealth Act and a valid State Act, the Commonwealth Act shall prevail to the extent of any inconsistency. Some people believe this makes mandatory vaccinations illegal, even if the state does them. The Constitution, however, is a special document, not being a Commonwealth Act, and Section 109 does not apply in the context of mandatory treatments. If there was a Commonwealth Act saying vaccinations are not to be mandatory and a State Act saying that vaccinations are mandatory, the State Act would be inconsistent with the Commonwealth Act and the State Act would fall under Section 109. However, there is no Commonwealth Act that says vaccinations cannot be mandatory, so Section 109 does not apply. Now, there may be a number of human rights protections against forced vaccination, but these have not yet been fully tested under Australian law. Some people have raised the Nuremberg Code, which is an international agreement that says that people should not be subject to experimental treatment unless they have consented to that treatment. It's only enforceable in Australia if it's in legislation, which is not the case apart from the ACT, where Section 10, Paragraph 2 of the Human Rights Act 2004 provides the right not to be subject to medical treatment or experimentation without free consent. The Nuremberg Code is a principle that should be adhered to ethically, but it's not a guaranteed legal requirement generally in Australia. Forced vaccinations represent an attack on bodily integrity, and without a valid consent may well constitute an assault. People should be able to freely choose what will be injected into their bodies. In Queensland, the Chief Health Officer has made several directions based on her emergency powers under the Public Health Act 2005, applicable in Queensland. These emergency-based powers are proposed to be extended out until 30th of April 2022 and apply while there is a declared public health emergency. The powers are very broad and recently included student nurses being excluded from a restricted vulnerable facility if not fully vaccinated, having not had both planned injections. Currently, This directive applies for a period up to 6 p.m. on 16th of July 2021. A restricted vulnerable facility includes hospitals, a residential aged care facility, disability accommodation, and correctional centres. These directions are all supposed to be temporary. If an employer tries to force an existing employee to be vaccinated, this may well constitute an unreasonable direction, and the employee may refuse unless the employer has a particular authority. If that employee is fired or is threatened with being fired if they do not comply with the request, this may constitute unlawful dismissal and can be fought in court. The proximity of the employee to vulnerable people may be a factor that the court would look at when considering if the request to vaccinate is reasonable. The court would also consider the risk to the vulnerable people and the risk profile of the employee through being exposed. The greater the risk, the more likely the direction to vaccinate would be considered reasonable. Now, if before being hired, an applicant is told this is a condition of employment and the applicant does not wish to be vaccinated, the employer is legally able to hire someone else. The decision in these circumstances is really a legitimate choice by the applicant. In summary, although it is unethical, unjustifiable, and a shocking intrusion on people's bodily integrity and human rights, the states have the technical legal power to mandate vaccines. The only solution is to tell them you oppose it, and if they don't listen, vote the wannabe tyrants out of power.